We are satisfied that this will meet a clear and pressing demand from those likely to be affected by the bill, and we should not underestimate the value in bringing this clarity to the law. Beyond that, it does not attempt to alter the law on delivery. Having said, Convener, what the bill does do, it's also worth briefly reminding ourselves of what it does not do. It does not deal with electronic delivery of electronic documents, nor does it deal with electronic signatures, or alter the law in relation to the use of pre-signed pages. The Scottish Law Commission's paper, entitled Signatures in Scots Law, Form, Effect and Proof, provides a comprehensive account of the current law on these last two matters, and the first is now provided for in legislation. Convener, I am aware of the criticisms levelled at the bill by the Faculty of Advocates. For such a body to raise concerns has rightly caused us to pause and give them full consideration. Having done so, we remain of the view expressed in the policy memorandum that the bill does not create any difficulties with the law as it stands, and it will, in our view, which is a view shared by the other Stage 1 witnesses, do nothing to increase the prospects of fraud or error as a result of executing in counterpart, including where only the signature pages are exchanged. Now, I have 4 reasons for that, but perhaps I can share those with you if members are interested under questioning. If I could continue by saying that it's worth commenting a little more about a particular possibility for error which was identified, namely that parties may inadvertently execute different versions of a document. In practice, if a document is transmitted to parties for signature, for example, in the form of a PDF, that will limit the risk of parties signing different documents. If, however, parties do sign different versions of a document, they will not, in fact, have validly executed it in counterpart in terms of the bill. The bill provides that a document is executed in counterpart if it is executed in 2 or more duplicate interchangeable parts. Nonetheless, this only matters if the transaction is by law one which should be in writing. In other cases, there may be sufficient agreement between the parties to constitute their contract. I will also say something more in the matter of exchanging only signature pages. The approach of the legislation has been to ensure that it is permissive and as flexible as possible. Inherent in that flexibility is the ability of the parties to a transaction to set out how the process will work for them. The parties can agree the method of delivery, and the parties can agree what will be circulated. That may be only the signature pages, or it may be, for example, the signature pages plus one counterpart. A crucial provision of the bill is Section 4, subsection 3, which applies only to delivery by electronic means, and provides that if only part of the document is delivered by electronic means, it must be clear that it is part of the signed document and must contain at least the signature page. Where the parties agree to only deliver the signature pages electronically, it will usually be because their solicitors are involved and there is an implicit relationship of trust between the solicitor and their client, with tried and tested methods for addressing any issues of fraud or error. In common with other witnesses you have heard from, the suggestion by the faculty to amend the bill to require that, for electronic delivery, the full counterpart is to be delivered by each party in all cases would, in our view, just not work. It would, as you have heard, also be unacceptable to practitioners and their clients and effectively undermine the objective of the bill. For these reasons, I hope the committee is reassured that the bill provisions do not in any way encourage fraud or increase the chances of errors occurring. In summary, this is a bill which one witness described as having aims which are admirable in the sense that they are trying to address a specific problem and to achieve a specific outcome, and that is an admirable ambition. It will plug small but important gaps in Scots law, and in so doing will punch above its weight and address the impact of the undesirable shift toward the use of other law, usually English law, to complete many business transactions, which should, for every other reason, be transacted under Scots law. I hope this is helpful to the committee, and myself and my officials will be happy to seek to answer any specific questions. Thank you, Convener.
Thank you very much, Minister, and that is very helpful, and I think it does preempt some of the questions that we have, but I have to say not all of them. So I now hand it over to Margaret McCulloch.
much. Minister, the potential benefits of the bill have been discussed in some detail with other panel members. However, could you expand on the benefits the bill will bring and how it would meet the policy objectives of the policy memorandum, for example, commercial expediency and saving time and money, consistency as well? The argument is that certain procurement contracts and land agreements have to be subject to Scots law and that no workarounds are therefore available, and also the promotion of Scots law. Could you expand if there is any other benefits on the bill, please?
Yes, I think there are benefits of the bill. I don't wish to overstate them, but nonetheless there are benefits, and I think that the fact that there are benefits is fairly clear and pretty much incontrovertible. And let me just answer this directly and answer McCullough's question. In circumstances where Scots law should have been used, but because of doubt, the existing doubt over the legality of executing a document in counterpart, it is not used, parties will now have the confidence to use Scots law. So that is a plain benefit. At the moment there's doubt, so if this, for practical business commercial reasons, is a method of execution which parties wish to adopt, because perhaps they are unable to be physically present in a room and traditionally sign documents, then they will be able to use Scots law, safe in the knowledge that execution in counterpart is valid. And in a world which is increasingly busy, the expectation that people can get into a room all to sign a document is, I think, unrealistic. It used to be, convener, that in my mother's day, when she was in practice, that when one completed a conveyancing transaction, that the two solicitors met, and in fact, indeed, I believe, I'm told by my mother, so it must be true, enjoy a glass of sherry as the conveyancing transaction was completed. Those days are long gone, and therefore execution and counterpart, I think, is simply bringing up to date using electronic media communication, where the parties so choose, with execution and counterpart of a method of being able to execute a contract under Scots law. That has not been possible. This bill will make it possible. The Scots Law Commission has probably put it much more elegantly than I just have, but I hope that I have described the principal benefit of this bill.
Thank you.
Thank you. All right, Stuart.
I wonder, Minister, clearly, as your introductory remarks made clear and the answer to the previous question expanded on, much of the activity between those who are contracting is delegated to lawyers. And the bill that's before us lays out processes in relation to this. I wonder if, in relation to some of the things that the Faculty of Advocates in particular has said to us, it is clear, in your view, that if there is a failure of process, perhaps minor, perhaps more significant, whether that actually compromises the legal validity of the resulting contract that's come through the process, where the failures are through those who are acting as nominees on behalf of the contracting parties, or whether by being permissive the bill simply creates a framework but does not make things that fall outside the framework inadvertently illegal in and of themselves.
If I've understood the question correctly, Convener, then I hope my answer is correct and my officials will no doubt step in if it is not. But my understanding is this bill makes no difference to the law in relation to the status of a contract and whether it is void or voidable where there has been fraud or error.
So just to play that back to you, Minister, this creates a legal framework which may be selected to be used, but if in practice other approaches are taken deliberately or inadvertently, they remain as they currently are in the law.
That's correct, and we do need to be clear that fraudulent activity is a deliberate act. And where someone is determined to carry out fraud, this bill won't stop that happening. That is of the nature of fraudulent activity. But the situation is no different to the current situation where determined individuals can carry out fraudulent activity. Perhaps, convener, it may be more likely to encounter examples of error rather than fraud, where I think through human fallibility, the possibility of error is omnipresent, as I'm sure we all appreciate very well. But this bill, as I understand it, makes no substantive change to the law which applies to determine whether or not, where there has been error, the contract and the validity, the enforceability of the contract is affected in any way. I think that's correct. And I'm looking to officials to see if that is so.
Yes, I mean, I think what I would say in most cases, we expect these transactions to be carried out, I think we've described before, by a PDF being sent, which I appreciate that there are means to alter PDFs, but that would require some deliberate act, and we're not in that territory. So that would minimise the scope for error. I think what we've also said is there may not be a valid execution in counterpart if different documents are accidentally executed, but that doesn't detract from the overview of contract law that there would still be sufficient evidence, depending on the circumstances, to constitute a valid contract. So this bill doesn't cut across existing contractual rules and remedies and different ways of rectifying errors that have been made, depending on the significance of the error.
Thank you. I think we're on to Mike. Please.
Convener. Minister, as you rightly said, that the committee took evidence from a range of witnesses, and the only opinion that was negative with respect to this bill was expressed by the Faculty of Advocates. All the other witnesses seemed to be pretty enthusiastic and welcome the bill. And we heard talk of how this would enable a number of contracts to be dealt with under Scots law, which currently people prefer to use English law. But none of the witnesses was able to give us any data, any feeling for the amount of potential business that this would direct to Scotland, either in terms of the number of contracts that would be signed under Scottish law now rather than English law, nor indeed of their value. And then the other benefit that we'd heard about this bill was the effect on the environment, the reduction in paper consumption, which may not be hugely significant, but nevertheless is welcome, and perhaps more importantly, the reduction in journeys required to sign contracts. I just wondered, does the Scottish Government have any data or is able to make any assessment of the number and values of of contracts that will now be written under Scottish law, or in any sense can quantify the environmental good that will spring from this bill?
Well, in response to Mr Mackenzie's question, I think I make the following points. First of all, the financial memorandum makes it clear that the bill is permissive by nature. It doesn't force or require anybody to do anything. It simply makes it clear that if a parties so desire, then they can use execution and counterpart as a modern, effective way to enter into a contract. And at the moment, that is not something that is clear under Scots law. So because it is permissive by nature, it is not really possible to predict with any certainty what commercial value may be. I'd say another couple of things, though. First of all, there should be benefits in some situations, and I think Mr Mackenzie has mentioned or foreshadowed some of those. Reduced expenditure on travel, postage and stationery, fairly obvious. Reduced amount expenditure of time. Convenience. Speed. It is very difficult to arrange multi-party meetings. If matters can be done satisfactorily by the use of PDF documents, as of course is widespread in use at the moment, and that can form the basis of validly executed contracts and counterpart, then that is a useful tool. So we are providing a useful tool. It's not really possible to state, what the benefit of this tool will be. It depends on how the business world in Scotland uses it. But it has been welcomed. It's been welcomed by the legal profession broadly, the Law Society of Scotland, the witnesses you've heard. And I believe that it therefore should be of potential value. I was pleased to note that the Press and Journal likes to cover stories that perhaps of less interest to other newspapers, promoted this bill very recently. So plainly, the more we can promulgate the change that I hope Parliament will choose to make, the better will be the appreciation of this as a new device open to business.
Thank you.
Thank you, Minister. I can't help feeling that actually it's the saving in time, which is probably the one that people will eventually decide was most important, because we tend to undervalue our time and the opportunities to do something else, particularly if we're travelling. That thought, then, I think we're on to Stuart McMillan, please.
Thank you, Convener. Good afternoon, Minister. Certainly on the 7th of October, when we took evidence from the Registers of Scotland, they had explained that they actually hadn't had any more detailed discussions with the Scottish Government on the possibility of setting up the electronic document repository. Given this, can you, Minister, provide us with some further information or any information regarding any detailed plans in relation to the electronic document repository, and also if it goes ahead, and also what the likely time frame for that will be?
I think probably my officials can help you out with this one, Convener, if that's all right.
I think when colleagues from Registers gave evidence, they spoke about other ongoing work to do with the implementation of the Land Registration Act, and that was their given priority at the time, and then they were going to kind of timetable their IT-related work. And I think we're taking that as our cue as to when they'll be in a position to have some discussions about this, but we've not had any further discussions at this stage. And we were certainly interested in the evidence that was given to the committee in terms of the views of the legal profession and some of the concerns that they had, and we'll consider that further. So nothing more at this stage, but when Registers are in a position to, we'll be taking that forward.
I think there's another point here, which is one that officials have made to me in private discussion preparatory to this meeting, Convener, which is this, that by the very nature, many of these documents will be very confidential in nature, and therefore there may not be a desire for the contracting parties to submit the contracts to be registered in any public form. It is possible to register any document that one wishes in the Council of the Books of Council and Session, and indeed solicitors regularly use these for registering wills after the death of the testator. But I think in general it may well be the case that many of the documents which will be executed in counterpart will cover commercial matters, in respect of which the contents would be intended to remain confidential. And therefore I think that's a factor that would need to be considered in respect of any electronic document repository, and whether or not to be such a repository that would provide for parties to preserve the confidentiality of the contractual documents, which would be something, of course, that would be necessary and desirable.
Thank you for the responses, but I think it would be useful, certainly for the committee, that if, as the bill is going through the parliamentary process, if we can be kept up to date, please, on any progress on this particular matter. Well,
I think given that it's been raised by a member of the committee, Convener, I will ask the Keeper to see if there's any further information that we can provide preparatory to stage 1 debate.
Thank you very much, Minister. I just slightly concerned that we don't confuse the two issues of an electronic signature with an electronic repository, but I'm sure the officials will separate those two in their thinking. I think that takes us on to John Scott, please.
Thank you, Convener. Afternoon, Minister. And I'm taking you back, I'm afraid, to the Faculty of Advocates' evidence on the concerns about fraud and error. You said that you had 4 reasons which you would give us by way of reassurance that this was not real fears that they were raising. And perhaps you might want to do that in your summing up to my question. But initially, I would just want to ask you, does this bill make it more or less likely that error or fraud will take place? We've just discussed that a bit, but if you would want to develop that theme a little more, please.
Well, I see no reason why the bill should either increase or decrease the likelihood of any instance of fraud or error. But I can, convener, expand, and I think on the reasons why we do not share the analysis that the Faculty of Advocates witness offered the committee, and out of respect to the faculty, I think it's useful to do so. So I'm grateful to Mr. Scott for having me providing me with an opportunity so to do. And the 4 reasons which I would put forward are firstly that the issue of fraud and error is not new. The risk of a document used at a signing ceremony being incorrect because of error or fraud exists currently. There are means to deal with this already in the civil and criminal law. The bill does not need to add to these. So there is an existing risk, and this bill doesn't alter that, in our opinion. Secondly, for the most part, clients will have placed their trust in solicitors, professional advisors, for the sorts of contracts that are likely to be executed in counterpart. Should an error go unnoticed and that error result in a loss to the client, they can have reasonable confidence that their solicitor is insured as they require to be and will be able to make good any loss. And indeed that applies both for the negligence and fraud. The indemnity fund, but there are 2 separate funds which solicitors must contribute to protect their clients. So the fact that a solicitor is used is a second reason why I think that there is no additional risk posed by this bill. Third, there is no evidence from other jurisdictions where execution in counterpart has already been used that there has been an increase in fraud or error. My understanding is that such usage has been legal in England and Wales, and that there has been no increase in the risk of fraud or error so far as we know. And I think the witness, Warren Gordon, gave evidence broadly to that effect. Fourth, I think Professor Rennie made a good point in his evidence that when he spoke of the example of legislation in 1970, which allowed ordinary conveyancing documents to be signed on the last page only, he indicated that at that time there was concern that the change might increase the risk of documents being changed after signature by removing pages which, if you like, hadn't been signed and inserting other ones. But he said in his evidence that there was no evidence to suggest that anything like that has happened. I must say I'm not entirely sure if that's 100% correct, because I'm aware of the case Brebner, where the dispositive clause in the disposition was altered by fraudulent means. And that was done, and had each page of the contract been signed, that would not have been possible. But by and large, that's an extremely rare occurrence, I think. So we remain of the view expressed in the policy memorandum that the bill doesn't create any additional difficulties with the law as it stands, and will do nothing to increase the prospects of fraud or error as a result of executing in counterpart. And finally, I would say that having had the opportunity afforded to me by John Scott, obviously if the Faculty of Advocates have, when they read this evidence, any additional evidence that they may care to adduce for the benefit of the committee prior to or indeed after stage 1, then of course we will accord any such additional evidence, should it be produced, with extremely careful consideration.
I hesitate to challenge a distinguished person such as yourself, Minister, but I mean the Faculty of Advocates were quite determined that full counterpart, signing in full counterpart was important, but you're quite dismissive of that as I understand on practical grounds it may not be easy, but perhaps you would want to just elaborate a little as to why you were so dismissive of that in your opening statement.
Well, I would say that where we don't accept the analysis of the Faculty of Advocates, we do of course respect their views, but we are not aware that in their evidence they cited any clear example of any instance in which the measures proposed in this bill would increase the likelihood of fraud. I've already said that fraud is something that no parliament or government can eliminate, as long as we have criminals who are prepared to engage in fraudulent activity. then that is sadly a reality. But this bill, if it becomes law, will not increase the likelihood of fraud, in our opinion, because the issue is not new. Solicitors will usually be involved. There is no evidence from other jurisdictions that, particularly England, that the practice has led to more instances of fraud, and there has been changes made since 1970 that not every page requires to be signed. Now, if the faculty has any specifics, convener, of why the arguments that I've just set out, then I would be very keen to see them. And I may say that this section of the evidence I've given today arose from a fairly lengthy pre-meeting that we had, which was convened primarily, in fact, almost solely, to discuss this issue, because we take what the Faculty of Advocates say extremely seriously. And therefore, I would welcome any further evidence if they feel what I've said this morning, or now this afternoon, convener, is in any way defective, because that would be a very useful contribution to the process with which we're all engaged to pass good law.
Thank you. I think that's very helpful.
Thank you, Minister. I'm also aware that the faculty suggested that there might be a complication with annexes that had documents in there which were themselves subscribed, and that was maybe not allowed within the Act. Now, the government's response has clearly indicated that you disagree with that. I wonder if there's anything you want to add to that.
Well, I don't think that that's the case, but I would draw attention to the provision of the bill which says that unless the document is executed in duplicate, it is not executed in counterpart and will not be protected by the bill. In other words, the documents that are signed and executed in counterpart must be the same. If they're different, then there will be no valid execution in counterpart. But perhaps I haven't addressed myself to the specific issue of appendices, so I don't know whether, if there's anything to add, officials could usefully add to that.
I think we have sent you a sort of note to sort of say, when we've looked at what the faculty have said, we don't think that is the effect of the bill. What is the part that is signed in duplicate? That is the counterpart, and not the individual annexes that may be associated with the counterpart. So in terms of section 1.2b, the reference to part means the counterpart part sounds at the level of the document. And we note that Professor Rennie, I think, also took that view when he gave evidence.
Grateful to you for just simply putting that on the verbal record. Much obliged. Thank you. I think there are just a couple of other thoughts that I would like to put in front of you, please. I'm specifically thinking about some of the evidence from Dr. Gillian Black. And I'm just wondering whether there's anything else to be said about a document which isn't actually correctly signed. And I have a feeling, Minister, forgive me, that you've probably addressed that issue, and this is only facilitative, and the general law addresses that. So maybe there's nothing else to say there. Could I then just pick up on the particular issue of counterparts as a single document in section 1.3, and whether there's anything that needs to be said to make it clear that it is one document, even though there's more than one copy of it?
Well, the first point you make, convener, I think is answered by stating that if parties inadvertently sign different versions of a document, they will not have validly executed in counterpart in terms of the bill, because it provides that the document is executed in counterpart if, quotes, it is executed in two or more duplicate interchangeable parts, section 1.2a. So the effect and the transaction will be determined under the existing law, as you rightly said, and much will depend upon the particular facts and circumstances. I mean, I think I'm right in saying, in response to your second question, that the answer is really very simple, that the parties in gremio of the document will describe what the document contains. In other words, the contract will give a description within the documents of what documents are part of the contract. A list of contents, including appendices. That is required for clarity, obviously. So I think that that really is the answer to the question. And that's perhaps just good drafting or conveyancing practice. However, I don't know if officials have anything to add to to either of those answers to either of those questions.
Yeah, I think Dr. Black was concerned with the legislation suggesting that two documents were to be treated as single documents. I mean, I would say we have thought that as a convenient way of describing the situation, particularly for the situation which parties want to register the document in the books of council in session, that it's important to explain that this is regarded as a single document. And yes, it's a legal fiction in some sense, but it does have precedent, I think, in other legislation as well.
So on reflection, it causes us no difficulties. And
that's our view.
Yeah, I think that's a view with which we would be wanting to agree. I think that takes us to the end of the questions that I'm aware of. I'm not seeing members wanting to indicate anything further. Is there anything further the Minister wishes to add, please?
I've never had an opportunity to use the phrase in gremio before.
I thought that was very impressive, actually, Minister. Some of us will have to go and look it up.
Could you perhaps enlighten us as to what it means?
Well, it means in the body of the deed, within the deed itself.
Thank you.
I'm grateful for that clarification.
That'll be 5 guineas, please.
I think that's a wonderful point at which to stop, to thank the Minister and his officials for being with us today. Again, just to note that this has all been very easy, I think, from our point of view. Great deal of cooperation all round, and it does seem to have worked. We will, as a committee, have the opportunity to reflect on the evidence we've heard for a draft report, which I think we'll get to look at next week. And with that, I thank everybody indeed for attendance and close this meeting.